The Indian Citizenship Amendment Act 2019, or CAA for short, passed by both houses of the Indian Parliament, has generated worldwide controversy. Some say the law is anti-Muslim. Is it? Some critics of the law say that it renders millions of Indian Muslims stateless. Does it? Some critics of the law say that it introduces religion as the criterion for citizenship. Does it? The CAA, quite simply put, is a law that fast-tracks the citizenship process for certain religious persecutees from 3 neighboring countries of India, which is Afghanistan, Bangladesh, and Pakistan, who fled those countries and entered India on or before December 31st, 2014 due to religious persecution. Before we get into the details of CAA, let us examine and understand what the law or the policy of the government of India is in regard to refugees who flee persecution and enter India. Pursuant to a standard operating procedure of the government of India published in 2011, any refugee who flees from anywhere on grounds of a well-founded fear of persecution on account of race, religion, sex, nationality, ethnic identity, membership of a particular social group, or political opinion can be granted a long-term visa by the government of India. Indeed, any refugee claiming such persecution has to individually demonstrate a well-founded fear of that persecution. This is comparable to asylum laws pretty much around the world. Section 207 of the Immigration and Nationality Act, the principal United States law governing immigration and nationality matters, has a similar standard. In due course, if such a refugee in India continues to get extensions for up to 11 years, he or she can apply for citizenship under the regular procedures of the Indian Citizenship Act 1955. This policy continues as it is. A 2018 government document published by the Ministry of Home Affairs confirms the same. In fact, senior ministers of the government of India have mentioned in press interviews that a total of 566 Muslims from Pakistan, Afghanistan, and Bangladesh were given Indian citizenship since 2014, which is since the current government came into power. Indeed, I would urge the government of India to release this data for public consumption so that the principal myth about the fact that this law will never give any Muslims Indian citizenship can at least be dispelled. It is critical to mention here that refugee considerations are often overridden by either national security concerns or concerns regarding bilateral ties between the originating country, which is from where the refugees have fled, and the host country, which in this case is India. The example of Rohingya Muslims, those who have fled from Myanmar, is often used as an illustration of why this law is anti-Muslim and why this law seeks to make India primarily a Hindu nation. First of all, it is vital to note that Rohingyas are fleeing from Myanmar, which was earlier called Burma. Myanmar is not one of the 3 countries listed in the CAA. Why does the CAA list 3 specific countries is something we'll get back to later. Secondly, among the Rohingya refugees who have fled Myanmar are also Rohingya Hindus. It's a less known fact, but there are Rohingya Hindus, also refugees fleeing persecution in Myanmar. Now, if the government of India were to say that we will welcome Rohingya Hindus but not Rohingya Muslims, one could still argue that this law is clearly anti-Muslim. Something similar to what President Trump said, that Christian refugees from Syria would be given priority. India hasn't said that. No one in the government has said it. Now, the stand of the government of India is that many Rohingyas pose a serious national security threat given that they have waged an armed rebellion against the Myanmar government. This is something that Bangladesh Prime Minister Sheikh Hasina has alluded to as well. Now, indeed, one can argue that this is the government of India's stand and it's not independently tested. Well, the matter is before the Supreme Court, which is hearing a petition that challenges deportation of Rohingya refugees. And therefore, it will be prudent to wait for the order or the judgment of the highest court of the land, which I'm sure will balance national security considerations versus the right of those refugees to claim asylum in India. There is also the question of Sri Lankan Tamils who sought refuge in India during the civil war and the high conflict situation in Sri Lanka. Now, this is an issue where preservation of bilateral ties between India and Sri Lanka come into play. Now, this issue has roots in a 1948 law passed by Sri Lanka called the Ceylon Citizenship Act. Sri Lanka was at that point of time named Ceylon. Under this law, which effectively provided one pretext or another, Sri Lanka did not grant citizenship to Indian Tamils living in Sri Lanka for several decades after India's independence due to pacts or treaties between the prime ministers of India and Sri Lanka. Several hundreds of thousands of Sri Lankan Tamils were granted citizenship of India. Due to continuous ongoing bilateral diplomacy between India and Sri Lanka, in 1988, Sri Lanka started granting citizenship to those Tamils of Indian origin who had not yet taken up Indian citizenship. And then finally, in 2003, the Sri Lanka government granted citizenship to all Tamils without any strings attached. The civil war, which resulted in severe bloodshed and humanitarian catastrophe, ended in 2009. Now, in addition to the 2003 law and the end of the civil war in 2009, there have been significant positive developments in bilateral ties between India and Sri Lanka. For example, in March 2015, Prime Minister Narendra Modi visited Jaffna, the Tamil-dominated area in northern Sri Lanka, the very first Indian Prime Minister to do so. Therefore, the question arises whether the Tamils living in India can still be considered refugees who continue to face persecution if they go back to Sri Lanka. Of course, there's no denying that many Tamil refugees who have been living in India have been living so for practically their entire lives. So this is not an easy question, no doubt about it. It requires continuous diplomacy between India and Sri Lanka, which do, as I said earlier, enjoy warm, affectionate bilateral ties. And therefore, as Finance Minister Nirmala Sitharaman suggested in one of the addresses to the media, the issue of granting citizenship to those Tamils who continue to be in India is under consideration by the government of India and hopefully shall be taken up in due course in the near future. Now, it is especially necessary to mention here that those who illegally migrate to India purely for economic reasons, maybe to get a better job or a better livelihood, they are not refugees fleeing any kind of persecution. They are what's called economic migrants. A predominant number of Muslims from Bangladesh and Pakistan fall into that category, unless of course they can individually demonstrate a well-founded fear of persecution, in which case they can be eligible for a long-term visa. But if they cannot establish such a persecution, then they are liable to be deported, not because they're Muslims, but because they're economic migrants. One could therefore ask, okay, what was the need of this Citizenship Amendment Act, which specifies certain religions from certain countries and fast-track citizenship for them? Now, before we directly answer this question, it is important to understand one myth that has been floated around about the CAA, in that the law does not mention religious persecution or religious minorities, which is why the myth that religion is a criterion for citizenship has probably taken birth. Now let's look at the text of the CAA itself. The CAA inserts new language in an existing law, the Citizenship Act 1955, which mentions that any person belonging to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian community from Afghanistan, Bangladesh, or Pakistan who entered into India on or before December 31st, 2014, and who has been exempted by the central government by or under Clause C of subsection 2 of Section 3 of the Passport (Entry into India Act 1920) or from the application of the provisions of the Foreigners Act 1946 or any rule or order made thereunder, shall not be treated as illegal migrants for the purposes of this Act. Now, on the face of it, one can say, okay, the Act only mentions specific religions. Where does it mention religious persecution or religious minorities? Well, principles governing interpretation of law require us to understand that if a law refers to other laws or incorporates other laws by reference, then we should look at what those other laws are. And forget legal principles, forget statutory principles, even common sense would suggest that if a law is referring to another law or a set of laws, then those laws have to be read together with the CAA. So let us see what those laws are. So the CAA refers to those who are exempted by the Government of India under the Passport Entry into India Act or from the application of the provisions of the Foreigners Act 1946. Now both these laws pertain, among other things, to the fact that any foreign national present in India must have a valid passport or a travel document and a valid visa. Now back in September 2015, the Government of India exempted those 6 communities from those 3 countries from the application of these provisions. Let's take a look at that language. So the 2 changes to these laws mentions, quote, persons belonging to minority communities in Bangladesh and Pakistan, namely Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution and entered into India on or before December 31st, 2014. Now both the laws mention the exact same words. And while these laws mention Bangladesh and Pakistan, Afghanistan was added in a separate amendment later on. Another thing that provides guidance is the Statement of Object and Reasons. Now most laws have what's called a Statement of Objects and Reasons, which essentially throw light behind the reasoning of the law. Paragraph 2 in particular of the Statement of Object and Reasons of the CAA says as follows. It is a historical fact that trans-border migration of population has been happening continuously between the territories of India and the areas presently comprised in Pakistan, Afghanistan, and Bangladesh. Millions of citizens of undivided India belonging to various faiths were staying in the said areas of Pakistan and Bangladesh when India was partitioned in 1947. The constitutions of Pakistan, Afghanistan, and Bangladesh provide for a specific state religion. As a result, many persons belonging to Hindu, Sikh, Buddhist, Jain, Parsi, and Christian communities have faced persecution on grounds of religion in those countries. Some of them also have fears about such persecution in their day-to-day life, where right to practice, profess, and propagate their religion has been obstructed and restricted. Many such persons have fled to India to seek shelter and continue to stay in India even if their travel documents have expired or they have incomplete or no documents. Therefore, what the CAA recognizes is that religious minorities in Pakistan, Bangladesh, and Afghanistan have fled those countries and come to India seeking shelter. So the purpose of the law is quite obvious. It is not to encourage further illegal migration. It is a one-time blanket amnesty of sorts to those who have entered India on or before December 31st, 2014. Either they've entered illegally or they entered legally, but their travel documents or visas have expired. Therefore, those entering India on or after January 1st, 2015 would not get the benefit of this blanket amnesty. Now here a question arises. Why this cutoff date of December 31st, 2014? This law, CAA, was first introduced in 2016, after which it was sent to the Joint Parliamentary Committee for discussions and deliberation. Now, prior to the introduction of the law, amendments to the 2 laws which we covered earlier were made in September 2015. Therefore, in amendments notified in 2015, the cutoff date of December 31st, 2014 made logical sense. The Joint Parliamentary Committee submitted a report in January 2019, almost 3 years after the law was sent to it for deliberations. Following its report, the law was introduced in the lower house of India's parliament right away. However, due to the ensuing elections, the lower house of the Parliament of India was dissolved, and hence this law could not be taken up for discussion. Once the current government won again in summer of 2019, it introduced the law in the winter session of the 2019 Parliament, which is when it was actually enacted into a law. Now, the object of this law was already made public way back in 2015, September of 2015, when these 2 amendments were made public. Therefore, despite the fact that this law was eventually enacted in the winter of 2019, this law could not have changed the cutoff date. Lest even if theoretically it could help certain people entering India illegally with the hopes of getting Indian citizenship after the legislative intent behind this law was already public. Now, the question that we referred to earlier but didn't quite address it, why these three countries? Well, as we read in the Statement of Object and Reasons, paragraph 2, the constitutions of all these three countries specify Islam as the official state religion. This is in Article 2 of all the three constitutions. Therefore, from among India's immediate neighbors, these are the only three nations which stipulate Islam as the state religion. Now, indeed, while the three countries do state that minorities would have the right to freely practice and propagate their religion, in practice, the persecution of religious minorities is a well-known fact. And we will see this later in the discussion in the context of Ahmedis who consider themselves Muslims, but Pakistan government and the Pakistan constitution does not consider them to be Muslims. Additionally, two of the three countries mentioned in the CAA, namely Pakistan and Bangladesh, were a part of undivided India until the time the British was ruling India. And when the partition happened, it resulted in tremendous cross-border migration and the resulting bloodshed. The third country, Afghanistan, which also shares a border with what India believes to be its territory of Kashmir, has several religious minorities who face persecution on a daily basis because of the influence of extremist groups like Taliban. So coming back to the main question, why these specific 6 communities? Well, firstly, it's critical to realize that CAA is not the only law governing immigration and nationality of refugees and persecuted minorities. Secondly, it's important to understand that it is not a law that renders anyone who is not covered under it any worse off in any manner. The effect of the law is not to state that only those covered under it will get Indian citizenship and no one else will. The refugee policy of 2011, as we earlier covered, remains as it is. The Citizenship Act 1955, which is the principal act governing immigration and nationality, remains as it is. What this law does is to identify historically persecuted minorities in those 3 neighbors where Islam is the official state religion. And by doing so, it effectively eliminates the requirement of members belonging to these 6 communities to individually prove persecution or a well-founded fear of persecution. In other words, what this law does is to recognize that these communities from these 3 countries must not be made to individually demonstrate persecution or a well-founded fear of persecution. Now, this selection is undoubtedly a policy choice of the government of India. Article 14 of the Constitution of India, as a general rule, prohibits unequal application of laws to anyone physically within India. It applies not only to citizens, but also to those who are inside of India. And therefore, one can argue that the analysis of the constitutionality of this law will be done under Article 14. However, the jurisprudence developed over several decades by constitutional courts across India permit what's called positive discrimination, which is discrimination in favor of a class defined or delineated under certain intelligible criteria. In this regard, it's important to mention one recent example of positive discrimination by the government of India, which has been held legal by our constitutional courts thus far. Pre-matric scholarships are given by the government of India to meritorious students only from minority communities. The specific minority communities enlisted as beneficiaries of the scholarship scheme are Muslims, Sikhs, Christians, Buddhists, Jains, and Zoroastrians, another name for Parsis. This law is constitutional, even though it discriminates on the basis of religion, and Hindu students, for example, do not get the benefit of this scholarship. And moreover, Hindu students don't get the scholarship under any other route, as opposed to the CAA, which does not prevent Muslim refugees from these 3 countries or from anywhere else, except of course for considerations of national security or impairment to bilateral ties, from claiming a well-founded fear of persecution and obtaining long-term visas and eventually citizenship if their physical presence in India meets the requirements of the Indian Citizenship Act. The other benefit that the CAA does is reduce the amount of time that historically persecuted minorities, specifically enlisted in the CAA, have to spend in India in order to be eligible to apply for citizenship. As we noted earlier, the regular requirement is 11 years. The CAA reduces it to 5 years for these specific communities. Another question does arise that why aren't Ahmadi Muslims included in the CAA, especially if the bill seeks to identify historically persecuted minorities on basis of religious persecution to religious minorities in these three countries. After all, Ahmadis are considered officially non-Muslims since 1974 due to amendments in the Constitution of Pakistan and the criminal laws of Pakistan, under which any Ahmadi who calls himself or herself Muslim is punishable for a prison term of up to 3 years and a fine. The Supreme Court of India, which is hearing these petitions on the constitutional validity of the CAA, will undoubtedly consider the issue of exclusion of Ahmadi. One argument is that nothing stops an Ahmadi Muslim from obtaining a long-term visa under the refugee policy of the government by individually demonstrating persecution or a well-founded fear of persecution. In that regard, the CAA can be seen as a policy decision to identify historically persecuted minorities and to grant them certain benefits without rendering anyone else any worse off. Indeed, the persecution of these historically persecuted groups mentioned in the CAA has been happening since 1947 when India was partitioned into two parts. And in fact, at that time, members of the Ahmadi community were at the forefront in demanding a separate Pakistan. Now, indeed, later in time, due to interpretation of Islam and the specifics of the religion, Ahmadis began to be considered as non-Muslims and they were ostracized. Therefore, the religious persecution of the Sikh communities mentioned in the CAA long preceded the beginning of the persecution of Ahmadis, at least officially under the Constitution of Pakistan. And additionally, Ahmadis do assert that they are Muslims, even though rulers of Pakistan believe otherwise and have passed laws preventing them and criminalizing if they consider themselves Muslims. But regardless of this, it will be interesting to see what stand the Supreme Court of India takes on the exclusion of Ahmadis. Does it give deference to the fact that the Constitution of Pakistan considers Ahmadis minorities? In India, Ahmadis are not considered minorities, they are considered as members of the Muslim community. Or does the Supreme Court give deference to the policy choice of the government of India to identify historically persecuted minorities since before Ahmadis and grant them certain extra benefits, again importantly at the cost of repetition, without rendering anyone else worse off? Well, time alone will tell how the Supreme Court decides on this specific issue. Now, the identification of historically persecuted minorities who don't have to individually demonstrate persecution has a parallel in a law in the United States, popularly known as the Lautenberg Amendment. This law specifically benefits the following: nationals and residents of former Soviet Union who are Jews or evangelical Christians, present or former nationals of Soviet Union participating in religious activities of the Ukrainian Catholic Church or the Ukrainian Orthodox Church. And in 2004, the law was amended to include religious minorities from the Islamic Republic of Iran. Now note that this law, just like the CAA, specifically mentions religious communities from certain countries and specifically excludes Muslims. Now, the hypocrisy of commentators in the West, and especially the United States Commission on International Religious Freedom, a bipartisan government body, is visible. Back in 2013, when Senator Lautenberg passed away, the US CIRF deeply mourned his loss, stating that for more than 2 decades he had championed a measure, which is the Lautenberg Amendment, which provides a vital lifeline to freedom for persecuted religious minorities. USCIRF then went on to urge the US Congress to make this law permanent. Until now, the law is required to be renewed annually. In February 2018, when the Trump administration denied asylum claims to about 100 applicants from Iran, mostly comprising of Christians, the USCIRF stepped in, urging the government to reopen their cases and grant them asylum status, stating that few policies embody this commitment of protecting religious freedom more than the Lautenberg Amendment. Now, when the CAA was passed by the lower house of the Indian Parliament back in December 2019, USCIRF published a very ill-informed press release raising serious concerns and mulling sanctions recommendations on India for enactment of the law, which, according to it, was a dangerous turn in the wrong direction. In conclusion, therefore, CAA is not the only law governing immigration or nationality of refugees or those fleeing persecution. By its very name, Citizenship Amendment Act, it is clear that it amends something. The Citizenship Amendment Act 1955, which it amends, remains as it is. The refugee policy of the government of India that we discussed remains as it is. This law identifies historically persecuted minorities who are persecuted solely because they follow a religion different than the state religion in those three countries. India has made a policy choice to form a category based on intelligible differentia and seeks to give them benefits without, and this cannot be emphasized more, rendering anyone else any worse off. It does not introduce religion as a criterion for citizenship. It seeks to benefit sections who face persecution based on religion in its three immediate neighbors. Now, common sense would tell you that if someone has been persecuted on the basis of religion, the benefits to them would also be given on the basis of religion. That does not make religion as a criterion of citizenship. The CAA does not prevent the government from introducing further similar measures to identify historically persecuted minorities belonging to other sections in other countries. For example, the Lautenberg Amendment included religious minorities in Iran almost 14 years after it was initially enacted. And lastly, the CAA is not a law to take any Indian citizenship. It is a law that gives citizenship. It's not a law that takes it away. So what is the source of this rumor that the citizenship of 200 million Muslims of India is in jeopardy? Some opponents of the Citizenship Amendment Act, CAA, argue that it's not the CAA that is the problem, it's the combination of the CAA with the National Register of Citizens, or NRC for short, which presents a dangerous combination. Does it? Now, the National Register of Citizens, or NRC, is an exercise which seeks to identify who is an Indian citizen and who is not. Unlike other countries in the West, India does not have an official list of who is an Indian citizen and who is not. Now, this leads not only to rampant illegal migration, but it also ends up in illegal migrants getting fake voter ID cards and other documents in order to get benefits which are otherwise normally for Indian citizens. Now, as of today, there is no nationwide National Register of Citizens. It hasn't been announced. It's only been proposed in public speeches and election rallies. So we don't know what the criteria of the National Register of Citizens process is going to be. And therefore, all the rumors regarding what documents would be sufficient, whether the documents that people generally have would be adequate or not, are simply just that, rumors. Now, these rumors might have potentially taken birth from the Register of Citizens procedure done in the northeast state of Assam. Now, the situation in Assam was a peculiar, unique situation. The Assamese people did not want migrants from anywhere belonging to any religion. They wanted Assam essentially for the Assamese people. And which is why there was a huge protest in the 70s and the 80s, pursuant to which the then Prime Minister Rajiv Gandhi signed an Assam Accord with the protesting organization. And because of that Assam Accord, certain changes were made to citizenship laws of India, under which the number one priority was to identify, detect, and expel illegal migrants residing in Assam. And because of laxity of governments over a period of time, the Supreme Court finally got annoyed and published a deadline in order to effectively start the process for identifying who is an Assamese and who is a citizen and who is not. Now, the Assam NRC process has flaws, which resulted in widespread confusion and even inefficiencies. It's important, though, to mention here that the Supreme Court was constantly monitoring the process, and no government could defy the Supreme Court orders, no matter how inefficient the process ended up being. However, India's Home Minister Amit Shah has categorically stated that the nationwide NRC has learned lessons from the Register of Citizens process done in Assam, and therefore, as and when the nationwide NRC will be announced, the lessons drawn from the Assam process will be taken into account in order to get into place an efficient system. So why then do the critics say that millions of Muslims will be rendered stateless? They give an illustration, and this is how the illustration goes. Let's say if the NRC is implemented inefficiently and results in a situation where an Indian Hindu and an Indian Muslim cannot provide enough documentation to prove citizenship of India. So both of them are caught in what we'll call the NRC net. So the argument of the critics is that the Indian Hindu who is caught in this so-called NRC net will still be able to save himself due to the CAA, which essentially, according to them, sets religion as a criterion for citizenship, which we have established it doesn't. The Indian Muslim, on the other hand, will be sent to a detention center and will eventually be expelled from India. Now this illustration is plainly bizarre. Why? Number one, the CAA will be rolled out first, followed by a nationwide NRC. Why do I say that? Well, the CAA has already been passed as a law by the Parliament, so it's ready to be implemented. Moreover, all beneficiaries under the CAA who, as we examined earlier, entered on or before December 31st, 2014, are eligible to apply as of December 31st, 2019, which is the 5-year period that we examined earlier. And furthermore, the Home Minister of India has categorically stated that the CAA will be rolled out first and then the NRC will happen. And indeed, I do urge the government of India to publish an actual deadline for applications under CAA in such a way that at no point of time do applicants of CAA apply when the NRC process is also going on. And that way, there's no way the CAA process and the NRC process could happen simultaneously. Now, a myth that has been propagated and which is useful to address here is that the CAA and the NRC are interconnected and that it's a dangerous combination. Quite simply, it's not. Firstly, CAA, the law, does not mention NRC anywhere. Secondly, as we discussed earlier, NRC is a separate exercise which will be rolled out after the CAA. So yes, there is a sequence, it's a chronological sequence, but it's not interconnected, it's not interrelated. For example, in the morning, if you have to do a 30-minute yoga session and have breakfast before you go to office, logically speaking, you would do the yoga session first and then follow it up with breakfast. Chronologically, the breakfast comes after the yoga session. But is the yoga session and your breakfast interconnected or interrelated in any way? No, they're two separate events that just chronologically follow one another. If and when the NRC is rolled out, and let's assume it's inefficient, for an Indian Hindu in the NRC net to subsequently claim that he's a member of the CAA pool will rather obviously lack credibility. Now, this is because in the NRC process, when the authorities come to his place, he would have first tried to claim that he's an Indian citizen and provided whatever documentation he has, which is considered inefficient. So for him to then say that he's from Pakistan, Afghanistan, or Bangladesh, and he entered on or before 31st December 2014, will be a rather incredulous claim. And therefore, let's assume, again, we don't know what the criteria is, but let's assume that the NRC process is extremely inefficient. In that case, both the Indian Hindu and the Indian Muslim, as well as the Indian Sikh, Indian Christian, Indian Buddhist, any Indian, would be affected equally. It's not going to matter whether someone is an Indian Hindu or an Indian Muslim. Now, one can, of course, hope that the process of NRC is not going to be cumbersome and it will be efficient. But for critics to say at this point that millions of Muslims will be rendered stateless and will be deprived of their citizenship is just plainly dishonest. So, in conclusion, wait for the NRC to be announced. It hasn't been announced yet, leave alone the criteria determined. If the NRC is implemented with some serious inefficiencies, the Indian Hindu will suffer as much as the Indian Muslim, the Indian Sikh, Indian Christian, any Indian. And therefore, this fear-mongering that Indian Muslims stand to lose their citizenship is plainly dishonest and, according to me, represents an evil intention of those who are opposing this law.